I will turn the presentation over to Drew Hirschfeld to cover the first two patent-related provisions.
Good morning, everybody. I wanted to say thank you for all of you either participating in person today or on the web for being here and partaking in this collaborative process. We at the PTO are very excited to hear your comments. We've received many comments already, and we're hoping that these roadshows are very informative to all of you so you can make more informed comments and we can start the back and forth that we need to implement these provisions in the best way possible. So personally, in my career, 16-year career at the PTO, this is one of the high points to be at the PTO and partake in such a process. It is something like I've never seen before, and I thank all the PTO people in the room who have been working tirelessly on all of these notices. So today I'm going to talk about the pre-issuance submissions and the inventor's oath and declaration, the two notice of proposed rulemakings. As I go through each of the details on the notices, I'm going to focus primarily on the office goals for the proposed rules. It's very important to discuss the goals because we want everyone to understand not only what we did, but the reasons behind why we did what we did. If you understand the reasons behind, we can have a much better conversation about where changes should be made. So to the extent you hear our goals and you may disagree with the goals, we would like to hear that, of course. And to the extent you agree with the goals, we would like to hear that as well. And of course, we're expecting that there's many times where you agree with the goals, but possibly have different ways to implement and reach our goals. And so, of course, that is information that we are hoping to get back from everybody. I'm going to talk about the key points and provisions of the two notices that I discussed. And I'll try to highlight what our goals were, as I mentioned, as I get to the provisions. So moving on to the pre-issuance submission, of course, the goal here is very straightforward. It's basically that the statutory provision is to improve the quality of examination and issued patents. Third parties can now put prior art, put references, printed publications, in front of an examiner during examination so that examiner can consider those documents in the examination process. I think it goes without saying that getting the best art in front of the examiner leads to the best quality examination and hence the best quality patent. Now, when we were looking at the rules and how to implement in our notice of proposed rulemaking, we wanted to make sure we were focused on efficiency of processing of submissions. So we didn't want to get caught up in provisions and technicalities that would slow us down. We wanted to make sure that we can get the references in front of the examiner as efficiently as possible and so that there's no delays at all. We also wanted to make sure that we were focused on the most relevant submissions. So to the extent that we could, we wanted to limit the number of references in front of the examiner so that examination is, of course, as most efficient as possible. On the next slide, I have 35 U.S.C. 122E, or parts of it, and this is the basis for third-party submissions being put in front of the examiner. That's the first bullet on there. And of course, it addresses that the printed publications of potential relevance can be put in front of the examiner and filed with the office and will be entered into the file for consideration by the examiner. The second bullet sets forth some of the requirements that a timely filed submission must include. The first one is a concise description of the relevance, and that I have a slide in a minute I'll talk about. And of course, there would need to be a fee. I have some slides on the fee, and then there also would need to be a statement that the submission is in compliance with this section. So moving on to the concise description, you need to explain the why and the how. It's basically why the document was submitted, and this is true for every document that's submitted, and how the document is of potential relevance to the examiner. This is, of course, important because it will help the examiner look at the reference and make the best determinations as efficiently as possible, of course, getting back to the goals. Now, the Notice of Proposed Rulemaking does set forth some best practices in how to do the concise description, but it doesn't mandate any guidelines. It doesn't say they need to be completed in any particular way. We wanted to leave it up to the third parties to be able to decide how best to make the submission. So what's most efficient and best for that third party to make the submission, we consider that to be sufficient to us, as long as you're explaining the why and the how that I discussed. We also will check to make sure that the concise description is more than just a bare statement that the document is relevant. So such a bare statement, if you have only that and nothing more, that submission would not be entered into the file. But if you have more than that, we deem that to be a sufficient submission. So the office does not intend to look past these two low hurdles to see if submissions are compliant before they're entered into the file. Again, we did this for efficiency purposes, to make sure that the art gets in the case and can be considered by the examiner. Now, moving on to the time periods of when third-party submissions can be made. These time periods are statutory. And basically, throughout our slides, and I'm going to take a break for a minute. I don't know if this was said earlier, but you'll notice so the text is black text. Black text we've left for statutory requirements, and text that's in blue is requirements that are not statutory but that we have in our rules. And this will help you keep identified and focused on what we've added in addition. So you notice that all the text on this slide is blue for the statutory time, or is black for the statutory time periods. So in order for a submission to be timely, it must be made before the earlier of either a notice of allowance or the later of 6 months after the date the application was first published or the date of first rejection. It's a little awkward test, but I like to look at it as a two-pronged test. Okay, the first prong, you need to be earlier than both prongs. The first prong is, of course, the notice of allowance, and the second prong is the later of what I've mentioned before, either the 6 months after publication or the date of first rejection. So when I'm evaluating whether a submission is timely, I like to look at the second prong first, figure out which is later of those two categories, and then compare that to the notice of allowance and determine which is earlier. And I have some examples to step you through. Okay, in this example, we have a 10 months first rejection, and then we have at 14 months, we have a notice of allowance. And then, of course, there was an 18-month publication. So if I'm going to the second part of the prong first, I'm looking for 6 months after the date of publication. That would be a 24-month time period. And I compare that to the first rejection, which was also in the second prong, and I look to see which was later. So in this case, of course, the 24-month time period was the later time period. Now, comparing that to the first prong, which is the notice of allowance, I'm looking to see which is earlier. And in this case, of course, the notice of allowance at 14 months was earlier than the 24-month period. So the 14-month time frame would control. And so any pre-issuance submission by a third party would have to be before that 14-month time period in order to be timely. Okay, in the second example, we have the 18-month publication followed by a 25-month first rejection, and then at 33 months you have a notice of allowance. So the times have just shifted in this example. So going to the second prong of the test, we look at the 6 months after publication date, and of course, again, that's 24 months. We compare that to the date of first rejection to see which is later. This is, again, the second prong of the test. And the first rejection date is later. And then we compare that to the notice of allowance to see if it's earlier than the first prong, if it's earlier than the notice of allowance. And in this case, it is. So the 25-month period would control. Okay, one more example. We have here 18-month publication again, followed by a 20-month first rejection, and then a 26-month notice of allowance. So again, I'll go through this a little quicker, but going to the second prong, you look at 6 months after the publication date. That's your 24-month time period. We compare that to the first rejection, which was earlier than that. So the later of the two is the 6-month publication date, or I'm sorry, 6 months after publication, so the 24-month date, and then comparing that to the notice of allowance, we see which is earlier. In this case, the 24 months is earlier, so the pre-issuance submission would be timely filed if filed before that 24-month time period. So it's a little awkward, but if you step through it, it's actually very easy to follow. Okay, now it's important to note with these time periods that they cannot be waived. They can't be extended either. They're set by statute. And also, one thing we've done now, if you look again, now I'm going to the second bullet and going to the blue text. So this is something we've added by our rules, but not by statute. The submission is considered to be timely filed, or it's considered to be filed on the date of its receipt by the office. Okay. And what we're getting at here is not the mailing date, it's got to be the receipt. So you cannot use certificate of mailing or transmission, and the date it's received in the office will be considered the time it's filed. Now, we did this because we were worried about papers crossing in the mail. And if we actually permit somebody to have something, a third-party submission filed on its date of mailing, there's a good chance or a possibility that it can cross in the mail with office actions, thus creating more work for not only the office, but potentially the applicant as well. So having a receipt date, we hope, will make this a much more efficient process. And once again, that is something we've added in our rules, but not a statutory requirement. A couple more points about third-party submissions. Third parties are not required to serve submission on applicant. And we were concerned here, this is again for efficiency purposes, we were concerned that challenges to service would impact or negatively impact pendency. We didn't want to get caught up in the, was this technically done correct? We wanted to make sure the art got in front of the examiner. Also, there's no duty on the applicant to reply to a submission, absent a request by the office. And the office is not intending at this point in the notice of proposed rulemaking to notify the applicant of entry of a submission into a case. Now, we did this because the submissions will be entered into the file. If they're compliant, they'll be entered into the file. And the applicant will be able to see them in the file. And of course, references will be considered like an IDS, so the applicant will know which references were considered and not. Now, some of the feedback we've received so far, are that the applicants do want to know when there's been an entry into their case. And I'm flagging this here as a point that we would love to hear your comments on how critical this is. Some applicants have said, we want to know as soon as something comes in because we may want to respond. We may want to look at it right away. We don't want to wait until, say, the next office action when we would notice that it's in the case. One possibility we have, and this is not in the notice of proposed rulemaking, is the possibility of an e-notification, something that we're just looking at and exploring, and we welcome your comments, and we'll certainly take them to heart. Okay, moving on to the fees. There's a $180 fee for every 10 documents listed or a fraction of the 10, with one caveat. There's no fee for the first 3 or fewer documents that are submitted in the situation where the third-party submitter states that this is their first and only submission, and then if they do so, they get 3 or fewer for free, And this encourages focused submissions of small amounts of art in front of the examiner. So moving on to an example. This example is the first submission by a third party in an application. And again, if you're 3 or fewer and you have this statement, that will be no charge. It would be for free. If you have anywhere from 4 to 10 documents, or even if you have 3 or less but you don't have the statement, your cost would be, the fee would be $180. And for 11 to 20 documents, the fee would be $360. And it would continue to go up in $180 increments. Okay, in example number 2, we have a second or subsequent submission by the same third party. So now this would be $180 for the first 1 to 10 documents. Now this is true even if you had 3 or fewer and you had the statement. when you had free documents. So you're probably asking yourself, how can you have if you had a first and only statement that said, this is my first and only submission, and now I'm having a second statement, how does that make sense? Well, we need to evaluate the first and only statement at the time you're making it. So at the time you're making it, if you make this statement and you don't believe you have any more references to submit, then you would have those for free. But if subsequently there should be more references come to your attention and you want to submit those, you would be able to. If it's 1 to 10, it would be the $180 fee, and then for 11 to 20 would be the $360 fee. Now, the way the examiners will consider these references are just like they do IDSs. They'll cross out references not considered, they'll initial references that are considered, and all the documents that are considered will be printed on a patent. And a final note is that third parties are not permitted to respond to an examiner's treatment of a submission. So if a third party does attempt to respond, that won't be entered into the file, won't be available in the file at all. Okay, I'm going to move on now to the inventor's oath or declaration. And I'm going to start with the goals that we had. And we would like, we tried to implement in the Notice of Proposed Rulemaking rules that would simplify the current rules while assuring efficient examination and minimizing pendency. Another goal that we had was to obtain the inventive entity prior to examination on the merits. Now, this is an important one because we've already received feedback on some of the way we've implemented. And basically, for us, examiners need to know the inventive entity to do examination. There's prior art determinations, there's potential double patenting rejections. So the inventive entity needs to be upfront for examination for efficiency purposes. If the inventive entity is decided later on during examination, rejections could potentially change. They could be removed, they can be added. So one of our goals was to make sure that the inventive entity was defined upfront prior to examination. Okay. Moving to the requirements of an oath or declaration, on statutory 35 U.S.C. 115A, except with a few exceptions, inventors have to still execute an oath or a declaration. I'll talk about the exceptions later on, but for the most part, barring those exceptions, inventors will have to execute an oath or a declaration. And there's a new requirement under 115B1 that the oath or declaration must state that the application was made or authorized to be made by the affiant or declarant. Now, this next slide, you'll notice, is all in blue, and that's highlighting that it's not a statutory requirement on this slide. And I'm going to spend a few minutes on this slide because we've already received some feedback, and this is certainly, if I'm going to point out in my presentation, one place where you want to look at and consider making comments, this is it, because we've received comments already. So here I have two requirements on this slide in the bullet, and basically the oath or declaration must be submitted on filing or shortly thereafter. What we mean by that is we'll have the same requirements as we do today, that the oath or declaration will be submitted early on in prosecution so that it's actually, or early on in filing the application so that it's before the examiner at the start of examination. So in other words, it'll be filed during pre-examination. We also have a requirement that the oath or declaration must identify each inventor. Now, both of these requirements, again, are by our rules, and we recognize at the PTO they are more limited than the statute. But the reason we did so was to make sure that we were getting an accurate inventive entity up front. So we thought the best way to get an accurate inventive entity was to make sure that the oath listed all of the inventors, and requiring that up front in pre-exam, make sure that it's in front of the examiner so the right patentability determinations in terms of double patenting and prior art can be made. Now, I've already mentioned some of the pendency concerns if we did not have the inventive entity decided up front. And of course, we're going to reiterate that, but there's potential rework. If you have, again, the inventive entity is not defined, the examiners may have to redo work, making more work for everybody involved and making this process certainly less efficient. And there's also a potential delay at allowance. Under the AIA, the statute does state that the oath or declaration can be filed up to the time of allowance. Now, if we were to permit that to occur, you could have a situation where you could introduce delays in prosecution. And what I'm referring to is you have an examiner who decides this case is allowable. You have first office action, second office action, either one, doesn't matter. If they decide the case is allowable and they go to allow it and there's no oath or declaration in the case, that examiner cannot allow that case. They would have to send out and they would have to delay the next office action to give the applicant time to submit that oath or declaration. So one way that we would handle this is by an ex parte quail action, which would close prosecution on the merits and give the applicant time to submit their oath or declaration. Could be done, but the problem we have and the concern we have is that would potentially would certainly add time on to prosecution. Now, it has been suggested that one possible way to get around this would be to have the inventive entity defined not in the oath. In other words, we would decouple the inventive entity from the oath or declaration, and one way is possibly to have that inventive entity set forth in an application data sheet. That is certainly a possibility, and we're exploring exactly that issue. And I'm not so sure it gets over the potential delays at allowance, but it certainly would be able to be an alternative for getting the inventive entity decided up front in front of the examiner. Under the AIA, it is possible to do this. It's also possible to not have the oath list each of the inventor and have the oath, each inventor files an oath that just lists themselves. Those are certainly possibilities, and I'm flagging this because we would like to hear comments. We're considering potential changes, but we want to hear what the public has to say. So, again, flagging this for something that seems to have been a hot topic. Now, for those of you familiar with our fees, or proposed fees, there is a potential fee. It was more of a placeholder that was discussed. It's not in the notice of proposed rulemaking, but it was in our proposed fees. This was a $3,000 fee for a late filing of an oath or declaration, and there was another fee for $1,700 for a change of inventorship. We have not decided to add these fees. There has been no decision on these fees, but those were simply a placeholder that should we decide to change the process from the notice of proposed rulemaking, we wanted to leave options open that maybe there's a fee, maybe there's not a fee. Those fees were basically to cover lost revenue from extensions of time that we would be missing out in the change, and also for programs to increase or to decrease pendency if there should be a pendency increase. So again, those were just placeholders, and I'm bringing that up also to flag it because we do want to hear comments on that as well. Okay, next I have a few miscellaneous provisions that I wanted to discuss. Under 115E, that provides for making the statements required in an oath or a declaration in an assignment. The second bullet sets forth the requirements. So you'll need the statements under 1.63 will need to be in the assignment. A copy of the assignment would need to be filed in the application, and the assignment would be needs to be recorded. And if that is all done, the oath or declaration could be made in an assignment itself. Another change is relating to CIPs in particular, and that a copy of an oath or a declaration from a parent application can now be permitted in a CIP application. Previously, or under current law, you cannot do that. You can do that in continuations, but not CIPs. But now we would permit, under the new proposed rules, a copy to be used in a CIP application as well, with the caveat also that newly named inventors must continue to provide an executed oath or a declaration, and that the statement in blue is that oath or declarations or the statements that filed must be true in the CIP applications. And what we mean by that is all the statements that were made, of course, need to still apply to the continuation in part, and if they do apply, you can make the copy. Turning to reissue oaths or declarations, our rule does include some more specificity for the examiner. This, of course, was done to help the examiners who are going through the author declaration. And looking to the first bullet, claims broadened in any respect must be treated and identified as broadening claims. And this is true whether or not that claim actually has some broadening components and some narrowing components. And then you also must identify each reason that provides the basis for reissue. Under current practice, you can state that the patentee was claiming more or less than had a right to claim. That's no longer deemed to be sufficient. You can state that the patentee was claiming more, or you can state the patentee was claiming less, but the more or less is no longer sufficient. And again, we were hoping to have more specificity for the examiner. I spoke previously about the exceptions to inventor execution, and those exceptions are set forth in 115(d)(2). And that's where the inventor is either deceased, legally incapacitated, unable to be found or reached after diligent effort, or refuses to sign. And with regard to when the inventor is either deceased or legally incapacitated, the author of declaration may now be made by a legal representative, which is true under current practice, but under the notice of proposed rulemaking would also be permitted to be made by an assignee and a party to whom the inventor is under obligation to assign, or a party who otherwise shows a sufficient proprietary interest. And my last slide sets forth priority claims, a foreign priority and domestic benefit, and that those will need to be done in application data sheets, as opposed to either in the author declaration in the case of foreign priority, or in the specification in the case of domestic benefit. So we had those put in application data sheets for ease of capture of the data. And that's all I had, and quite an ending. So we're happy to take questions. I'm going to turn down, and if there's anybody else.
Yes, sir. Please come to the microphone so that the audience can hear your question.
My question concerns what you said on the oath of declaration. I work for a very large company, international company, who has research organizations all across the world. And the problem we have is that people come and go on a frequent basis. We typically file first in the PCT, so it's 30 months before we file in the U.S., and by 30 months, people have left. And tracking them down in China and in France and other places becomes exceptionally difficult. So, when we file a PCT application, you have the inventors listed. So you shouldn't, you shouldn't need anything further, the oath or declaration, at that point in time to establish the inventive entity. I mean, we put it in the PCT. So I would strongly encourage you, with respect to your processes, to adopt some kind of application data sheet. I understand the need ultimately for an oath or declaration, but putting it up front often presents an impediment, under the circumstances I've elaborated.
Well, thank you. Thank you very much. And all I can say is please submit those comments. And this is, as I flagged, an area that we're hearing differing opinions, and many have had similar comments to yourself. So to the extent that people make comments, that would be very helpful for us in how we move forward. Thank you.
Yes, sir. Question.
Just a quick comment on the issue of the declaration clause. There is another ground for the issue of the circuit, so-called head-to-head conflict. Probably you want to add that. Did everybody hear that, or I need to repeat it? No. There's a new ground for reissue applications pursuant to Inventor Execution 2011 decision. Probably a good idea to add that ground for reissue to your proposed grounds in your proposed rule.
Thank you.
Other questions? Oh, yes. Yes, sir.
I'd like to speak for the small inventor and the $1,700 fee for change of inventorship. In particular, I'd like to bring up the scenario of an article written by, say, 4 individuals that are authors, and you look at your original claims and you come up with the identity of 2 or 3 of those as being the true inventors of what you have claimed in the invention. And then during prosecution, you come across the fact that this embodiment is not as popular as this other embodiment or whatever, and we now have a change of inventorship, and we have to pay $1,700 to create a change of inventorship. I'd like to seriously consider whether that, in fact, meets this balance between expenditures and actual fees for doing that.
Thanks. Before we get too concerned about that fee, remember that was simply put out there as a placeholder in the Section 10 rulemaking. That hasn't even been proposed yet, and what form it would take, we're far from there. So we will consider comments like that. Thank you.
Yes, ma'am. I think yes.
This is about the possibility that no third-party submission would be allowed in those applications that were lucky enough to receive a notice of allowance, a first office action notice of allowance, in a regular, that is to say, a default track examination, or in a fast track examination, especially if the application is not yet published but has also received a first rejection or resolved issues. Is that something that you're aware of, and is that going to be, is that the statutory rules right now going to remain, or is there going to be some possible tinkering?
Well, the time periods are set by statute, so we can't adjust the time periods. Now, as the example showed, you may have less time, as you're pointing out, to submit in certain situations, but again, we're not able to change the statutory language.
So please come to the microphone so that the audience and webcast can hear you.
Yeah, I'd like to address third-party submissions and notifications of the applicants. I think a lot of reasons I would, for one, want to know if a third party has filed an application after publication or whenever. But there are also strategic reasons that some companies may want to do that, and there may be benefits in making sure that both sides, I mean, at least the applicant is notified of a third-party submission.
Thank you very much, and we have heard others make similar comments, and I would ask that you submit that as well. And we certainly are looking into possible ways we can notify, such as the e-notification is one possibility we're looking at.
I don't mean to monopolize the questions, but in regard to the $180 for the 10 submissions and a fee that is free for less than 3, let's take the hypothetical that somebody wishes to make a submission and it's merely, I think you use the words, a bare statement that this is relevant. Well, in an information disclosure statement, that's all we're doing today, pretty much. But in the future, what I see is that the applicant will be making almost a claim chart. We'll put together the published application claim, and then we'll say, here's the prior art on the right-hand side, and it'll be a 102 or a 103, and we'll identify those 1 or 2 or 3 rejection. But if we don't, do we get our money back? So I think we've got 2 or 3 questions in one here. Number one, where is the line going to be drawn between the bare statement of relevance, which is actually all that's required today? Number two, the other side of it, where we have the claim chart, and are we going to get our money back if we don't meet the standard, whatever that standard might be?
Well, I'm not sure I understood. It seems you're saying something about submitting detailed and not having a detailed explanation and not having that be considered sufficient. But basically, the hurdle that we have is the bare statement. A person other than the examiner will likely review that submission when it's sent in, and if there's more than the bare statement there, then that would be sufficient to be entered into the file. In the case,
something as simple as look at Figure 4 would be sufficient, or we don't know.
I think my answer is I don't think we do know, because I think that that certainly might depend on the technology and what's shown in Figure 4. So I think that has to be almost on a case-by-case basis. But if, what we were referring to with the bare statement was simply this is relevant, something to that effect. So if you have more, we're going to deem that to be sufficient, and we're purposely taking this line so as to make it easier on the third parties to submit.
For our webcast audience, I don't want you to think we've forgotten about you, so if you please type your question in through the web chat feature, I will ask the question for you. Yes, sir, on the left.
If a submission is made, but it is not accepted by the PTO, and we are notified, does that create a duty to disclose?
You're saying if the applicant is notified?
Third party makes the submission. The PTO doesn't accept it because the statement's inadequate, the fee is not paid, something like that. We are notified that the submission has been made. Does that create a duty to disclose to the applicant?
So the PTO wouldn't notify, but you're saying if there was notification in another way.
If there was a notification to the applicant.
Notification to the applicant, that would be up to the applicant to decide whether that reference, falls into their duty of disclosure.
Thank you.
Okay, well, I think
Yes,
Bob would like to add something to that one.
I think we've indicated in our rules that the answer would be no, that you wouldn't. But you have to, our plan for reviewing these concise statements is we really plan to only reject if it's just not there, or if it's just, this is relevant. For the gentleman's example, see Figure 4, we think that would probably be okay unless 10 references were provided and all of them said see Figure 4 and half of them didn't have Figure 4. So, we don't plan to put a lot of energy into policing these statements. We want to get the prior art in. We want to make that an easy process. So in all likelihood, it would be accepted by us and the situation won't arise.
Yes, sir.
Mine's just a request to be clear on this, because when you file an IDS, you put a listing of it. There's no requirement that you give some kind of statement in your own case. But if you got a priority document, it might be an EPO document where there was a search done, they will frequently put in column this, figure that next to each reference and indicate the relevance with high importance, background, or whatever. Is that sufficient? Can you say that would be sufficient?
Yes.
Okay.
Yes, ma'am.
Have you guys thought about any safeguards to prevent, to help small entities with this pre-issuance submissions, for there not to be a deluge of the big companies, shall we say, wallpapering the walls with 50 of them in order to, keep us in adult diapers before it gets all done?
Well, other than the fee that we have proposed, and obviously if we saw this being abused, we can adjust fees under Section 10 to put a lid on it. Excuse me?
So after the abuse?
Well, if we see somebody getting abused, yes, that happens, but someone will have to pay a lot of money to do that.
But after the abuse? Because you have to realize that those of us that have smaller patents that do, shall we say, tend to push towards bigger technologies where the big guy does want to, they're willing to pay your fees many times over.
So right now, under the notice of proposed rulemaking, what Bob is saying obviously controls that right now is just a fee. But certainly we would like to hear from people if this is a concern. And it is still a notice of proposed rulemaking, and we're in the collaborative process, so the more feedback we can get about concerns, we will take that in consideration, and there is potentially something that can be done.
Okay. How about we go on the left, or the right? The right.
Right. Go ahead, sir.
For prior art submitted by a third party after a first office action, what's the standard going to be for whether the examiner can rely on any of that art in making a final rejection?
I'm sorry, could you repeat that?
If a first office action is issued and then a third party submits prior art, what's the standard going to be for whether the examiner can rely on any of that art in making the next office action a final rejection?
It's not an information disclosure statement, so it would be the same standard. You know, did an amendment necessitate the final?
Okay, but under the current standard, if you can certify that if it's your own IDS.
This isn't an IDS. This is a different thing.
So
it would be like the examiner found documents from another examiner.
Okay, so if it was necessitated.
Yeah.
Okay.
With regard to the provisions, and I believe it's 115, the provision to allow a legal company, for example, a legal administrator in a company to file an oath on behalf of the unavailable inventor, I would just like to encourage you to be flexible in that regard, because a lot of times we do make companies do make a diligent effort, and we've had37 CFR 147, where we've gotten a great deal of pushback from the office, and we sent it registered mail, and they said, oh, that's not good enough. So, I want to be, encourage you to give us the benefit of the doubt, as opposed to make us jump through 100 hoops before we finally can say the inventor isn't available.
Thank you.
Just two quick questions. How will third-party submitted art be identified on the printed page as identified by the examiner, or as with a new identification as third-party submission?
So we envision to create a form just for the third-party submissions, and so that form would indicate if there's a third-party submission. Were you also asking about on a patent? Okay. So
on the face of a patent.
No, I was going to say that's an implementation detail. We haven't worked that out yet.
Do we have other questions about pre-issuance submissions or inventor's oath declarations? Anything from our webcast audience? Well, this brings us to our morning break, so let's return here at 11:30, and we'll continue our conversation on patent issues with the miscellaneous post-patent provisions and supplemental examination.